Welcome back to the PI Show, viewers. Before the break, we were talking about two very large judgments obtained in the Supreme Court last year by one of our very experienced and learned colleagues, John Karantzis. Harry, we're talking about the case of Pham.
Yeah, and that was a $1.1 million verdict. John, it's a jury verdict. How long did the trial actually take?
12 days, Harry.
12 days? And who gave evidence in the trial?
The plaintiff, the worker, gave evidence. He was severely cross-examined by the defendant's QC. However, he came out unscathed. He gave evidence as to the injuries he sustained and the work that he was required to do by the employer, which produced those injuries.
There was a couple of co-workers that gave evidence about the nature of the work as well, wasn't there, John?
Yes.
And there was, dare I say, video evidence of what the work was. The employer said it was light work.
The employer tried to
say it was light work.
Say it was light work. However, the jury saw through that in the end.
And the jury was, what, 6 females?
6 female
It's unusual.
jurors. It is
That's
unusual.
6 people off the street, so
yes,
it's sort of unusual.
Yes, it was a mixed bag.
And how long did they take to actually reach a verdict on this matter?
About 3 to 4 hours, Harry.
Well, it's very quick.
Yeah, it is pretty quick.
Because usually juries are out for a bit longer.
I think criminal juries take a long time.
Do they?
In civil cases, yeah. I think as the case is going, they're probably mapping it out in their mind.
Yeah. So they answered 2 questions.
2 questions.
Was the defendant negligent?
Yes.
How much damage should the plaintiff be awarded?
They awarded $250,000 for pain and suffering damages and over $800,000, $817,000 for economic loss.
Which is loss of income.
Yeah. And Mr. Tran's reaction?
He was crying. He was crying.
Burst into tears.
He burst into tears. He was thankful. It was
a
tough case.
Did he give you a hug?
Oh yes.
Gave you a hug?
Oh yes. Yeah. No, it was a very emotional time.
Yeah. Yeah. Well, the whole family would have been there.
Whole family. So his parents, who were Vietnamese boat people that came to Australia in the early 70s.
And I think he left school at year 10.
Year 10.
And went straight to work for the factory because his brother was there.
His brother was there and his cousins were there.
And cousins were there.
Yeah.
So it was hard working.
Hard work. Worked there for a couple of years. And then this incident occurred.
Yeah. Now, tell me this. The next case was, again, every case is different. It was an electrician who fell off a ladder in a lift shaft.
Yes, it's
had his leg caught, his ankle caught.
The ankle was caught in there.
And severe damage to the ankle.
Yes, the matter of Linton Sheriff, and Elzac was the employer, who is run by Roy Morgan. We ran this case in March 2010 in the Supreme Court again, initially with a jury. However, the jury was discharged because, well, the complicated legal issue, Harry.
Yeah, there was a legal issue about the judge wasn't confident the jury could decide one of the legal issues.
Well, both parties agreed that they didn't want the jury, Harry.
And both parties agreed.
Yeah.
The defendant was said that our client, the worker, was not an employee, was simply a subcontractor.
An electrician subcontractor.
Yes.
Yeah. Well, Harry, if he's not an employee, what does that mean?
He's a subcontract. He's working on his own, under his own control and initiative. But I can't follow why the defendant said that even if he was a subcontractor, the occupier, the person who owned the building, didn't have some responsibility. I can't follow, but anyway.
But it was the nature. Yeah. Look, the issue come down to the system of work, Harry. If he was an independent contractor, the system was devised by himself. And if it's working under an employer, well, the system's devised or should be devised by the employer.
It was the incident on the day, because I think bizarrely the plaintiff suffered some injury and saw a doctor that morning.
Had previously suffered an injury to his hand
and had a bandage, I think, the morning of the incident.
Exactly, at hospital. And then in the afternoon, he's asked by the employer to go down the lift shaft to make sure the lift shaft, the lift is actually working.
I think
It
the
wasn't
lift had
working.
broken down that day.
Exactly, and he's
I-
directed by the employer.
The employer said it was urgent. You couldn't get anyone else. You have to go down.
It's,
right
it's outrageous to expect someone to climb a ladder with a bandage on his arm in a dark lift wall. He's got no control over the ladder. How's he going to work with one hand and what's he do with the other hand?
That was a important factor.
Well, that was what the judge found.
Yeah. But the other interesting thing was the plaintiff told initially that he'd been hit on the head while standing on the ladder by the lift coming down.
Linton thought all along that he was hit by a descending lift whilst
On the ladder.
On the ladder in the lift shaft.
Yeah.
Judge found otherwise.
The judge found the system of work was unsafe.
Well,
The
that he
system of
fell
work
off the
was
ladder.
unsafe and that he had fallen off the ladder. And part of it, as a contribution, was because of the
He didn't have proper grip
injury to his hand.
with his
Yeah,
hand.
he had no grip on the ladder.
But John, I think my understanding is the defendant lawyers thought if his version of events wasn't believed, he would fail.
That's what they thought.
So they underestimated the skill of the lawyers for the plaintiff.
He also suffered severe injuries, Harry.
Yeah.
He's thinking of having his leg amputated because of the severe pain that he's having.
So, but there was no argument about how significant the injury was.
No.
Really, it was about legal issues.
Exactly. Whether or not he was an employee
How did the accident occur?
and how the accident
There were no
occurred.
witnesses.
There were witnesses outside of the lift.
Yeah, but there were no direct witnesses of the accident.
What did he get? Because time seems to be flying as usual.
There's contributory negligence.
Contributing negligence of 20%, as in the judge said that
He was partly to
he
blame.
contributed to his own accident, and therefore there's a deduction of 20% from the damages that was awarded to him. He was awarded $450,000 for pain and suffering, 20% reduction, which made it, I think, $320,000.
Yeah.
And he was ordered the maximum for economic loss, which is $1.175 million, which was again reduced to $940,000.
By 20%, because of 20% came
Exactly.
off. And
So it's over $1 million verdict.
yeah, I think 1.2 million. And,
Yes.
and again, I think to my knowledge, they're the only two trials in the Supreme Court for $1 million last year.
Last
Tony.
year, that's right. In fact,
So-
I've never seen one lawyer run and
One-
win two matters
Two
over
matters.
$1 million.
No,
in the last 10 years
it's,
anyway.
It's,
So.
it's an unusual event.
We're going to have to go to another sponsors break. John, I want to thank you for coming on the show.
Thank you, Harry.
Well, John, the $1 Million Man.
Very
But
informative.
We can have him back for another episode.
Yeah, we're going to have to get him to win some more cases. And
Win
then,
more cases in 2011.
viewers,
I think
don't. We're going to have to go to a sponsors break, guys. Viewers, don't go away. We're going to come back to the mailbag very shortly with Kathy. So stay tuned, and we'll be back shortly too.
Thank you. Thanks.